Hello, everyone. I'm Carol Parker. I'm the director of the library at the University of New Mexico, and welcome very much to my session on DSpace. Before I get into the nuts and bolts of this, I'd like to just read you a few quick headlines. Tectonic shifts in scholarly publishing. Open access journals flourish. Public access to NIH-funded research. Taxpayers commend precedents set by NIH public access policy. Oxford Journals launches Oxford Open, a new open access initiative. Europe steps into the open with plans for electronic archives. Dutch academics declare research free for all. Britain, a leader in making research available on the web. And one of my favorites. Scholarly journals' premier status is diluted by web. More research is free online amid spurt of startups. Publishers' profits at risk. Again, momentum towards free online publication of scientific research is becoming unstoppable. Written just a few days ago. What's going on? Any information professional has probably seen headlines like this and been vaguely aware that something's afoot. But if you're anything like me, until the last 6 months or so, you regarded this as an issue for other disciplines, not something for law, and pretty much dismissed it. What we're going to do in the next hour is review the background of this open access movement. And we will look at a couple of the software applications that are available that allow people to put research and other material on the free web, the digital institutional repository. I will begin today by giving you a quick overview of a new institutional repository that became available at the University of New Mexico just a few months ago. And then we will close out today by talking about the implications of this movement for legal scholarship. And hopefully we can discuss what we see coming out of this for us, if anything. I'll begin with just a quick overview of DSpace. Later we'll look at this in a little more detail. But DSpace is, as I mentioned, an institutional repository. It allows researchers, it allows universities, if you will, to place their research in this server-based repository through a decentralized submission process. Literally, it's very similar to the way you would load a document into a Twin page, or you would attach a document to email. It's that simple. But in the process of submitting this to the server, the submitter adds metadata, and then you also receive a permanent URL for that item. So the item is sitting there on the web. This is what we would call gray literature. But the process of loading it into the DSpace server makes it a lot more accessible to others. In large part because Google is now indexing DSpace. And they're indexing the metadata that you add during the submission process. So you have control over the keywords that you use, and you can use your terms of art. And that's the beauty of the decentralized submission process. You know your terms of art. You know what other researchers interested in your field are likely to search by. The metadata in the DSpace system is based on the Dublin core metadata. And there are a number of institutional repository programs available. We'll look at some of the highlights, some of the larger, more significant ones today. But the really nice thing about DSpace in particular is it will support any file format. Unlike a number of them that are geared at text only, are based largely on PDFs, converting text into PDF. You can put anything into DSpace. Now, of course, your user, presumably, if you put certain applications in there, your user would have to have that application open. But this is coming out of non-legal disciplines. So they are geared at data sets as well as at text files. So it's very flexible. This is just a quick diagram of the concept, if you will, for the submitter and the user. A little later we'll look at the architecture of the software itself. But the concept would be that, as you see there on the left, you have submitters out there, and they're pumping these objects, whether they be text files or data sets from research, into this system. And in the process, you add metadata. It would be that first small little item there on the bottom, the little bar. The item and the metadata together go into collections, which are stored in communities of users. And then those are freely searchable by the end users. Again, Google is indexing DSpace servers now, so it's freely available to the world. And then you do have some collection control. You would see the description of the little curator there at the top. You could set this system up so that the curator had a gatekeeper function and could ensure or add to the metadata and ensure it was appropriate to go into the system. Now, this particular application, this open source package, was developed by MIT and HP, and they hoped that it would lead to a federation of similar repositories around the globe. And they released it as an open source license in 2002. At the University of New Mexico, our server came available just in March. They're doing a soft rollout now throughout campus, and they're in the process of encouraging other colleges and departments to use this. It was the code and the server setup were handled by the electrical and computing engineering department, but they turned it over to the university libraries to add that policy component and to help people work with metadata. And the server is currently housed at our Computing and Information Resources and Technology Department, our central computing. And our plans to have the mass storage devices to this to back up the data. And our use within the University of New Mexico School of Law to date has been one of archiving only. There are other uses for repositories like this, primarily online publishing, but we are still in the process of working out those types of policies and procedures. We have added to date only items that are in the public domain or have been generated by the faculty. We're still trying to figure out what permissions our faculty might have, or what they might have retained, I should say, to allow us to hopefully go back post-publication in journals and add some of their articles to this. But as we discovered when I first described this to the faculty, I said, well, did you all retain the right to take your work and archive it? You know, I don't know. I have no idea. But as a common phenomenon. So we want to be very careful about that before we add anything. But that's the next step. Now, we added a link to DSpace, for the moment at least, off of our databases page. So if you are a U of M person, you would go in here to find where I'm linking back to other university resources as opposed to law school, which is on the left. That's where I currently have the DSpace link. And here's a look at the U of M, UNM DSpace. You see that we have a number of communities that have already arisen in just a few short months. I have a law library community, and we also have a law school community. I'll give you a quick tour of the law school community. reminds me a lot of Twin, and the ability to load a little logo and put the descriptor at the front page describing what it is. I have, the Indian law folks are very excited about this. So much of their material is local, stuff they have in their file cabinets. They're just thrilled that now we have an outlet. We can scan our brains out. We have a place to put this very easily without burdening the IT folks, and by decentralizing the submission, it makes it a lot easier. I'll show you a couple of the water documents we have in here today. We're in the process of training a staff person to sort of be our DSpace guru and help the faculty with metadata and submission issues. One of our faculty members chaired President Clinton's Western Water Policy Advisory Review Commission back in 1998. So she has literally file cabinets worth of transcripts from hearings, transcripts from conferences, that type of thing. And those are being digitized now, and they have a place to put them. The abstract was added as part of that submission process, and the faculty have to work with us to come up with a suitable abstract. And you had a lot of documents in here. You could keyword search, and if you noticed on that previous screen, you can keyword search or you can browse. We browse by title. We see that a number of the documents have been added. I'll go directly to the final report that the commission issued. And what I did, because it's in PDF, I loaded the entire report up there. You'll see the first submission is the final report, complete file. But I also broke it down for folks believing that folks with slower connections might still want to try to get into this. And I'm not going to go through the submission process completely with you, but you just load the documents in there, obviously. Now, if I were to load something, I would log in on the left. Go ahead and log in. And you can sign up for email alerts to see if something's been submitted to your community. And it looks like I have an unfinished submission. I will ignore that for the moment. But let's say I wanted to submit something to my community. I've learned that it's better to go in on the left and drill down into the community than to use their quirky wizard. I'll scroll down to law school. Say I wanted to add something to the Indian law community. And we wanted to put it in the trial transcript collection. You simply submit to this collection, checking things as appropriate as you go. This would be what you checked if there was more than one file in this particular document, which is the case where I broke them up into parts. And you go through the template and add the metadata, etc. I'm not going to take the time to finish this, but it's just that simple. And I'd like to show you something in this trial transcript collection, for example. This is a trial transcript of a very significant Indian law case. And the prof had the copy of the thing as a federal court case, hundreds of pages. We broke it down by witness, scanning this, adding it. But watch what happens if I would go to Google and I search for Santa Clara Roanoke versus Martinez. The third item is our transcript in DSpace. Just like that. faculty's eyes got like that. I can put anything I have into Google just like that. Seriously, if you have the rights to load it in there, you do. Again, it's the concept of a repository. It's an archive. You don't want to be putting things in here that you need to change and update a lot. When they go into the database, they should stay there. In fact, in the process of submission, you are giving the university a license to maintain this, copy it as necessary to preserve it, migrate it if needed to keep the format viable. You don't want people putting things in and pulling them out and updating them. This is an end-stage repository, if you will. But as I mentioned, people are using it for other purposes as well. People can use it for online journals. Create a web gateway, put the articles in the repository, and you have a homegrown online journal. Yes?
Is DSpace providing any type of real-time awareness push of new items as they are?
Just an email alert. If you sign up for an email alert, yes. But at this point, they're not syndicating any feeds.
Do you want to provide?
Well, we'll maybe at the end of the session, if we have time, we can take questions like that. I'd like to try to stay on point at this point because I have a lot of material. Let me just say, the slides include links to resources. I will almost certainly not have time to cover everything that I have linked to. So the resources that I mentioned will be available to you after the presentation on the web. So they will be there as a resource as needed. At this juncture, I'd just like to kind of give everyone some of the background on the open access movement, which partly led to the development of repositories like this. The concept, as I'm sure you all know by now, is that scholarly communication should be free to the world as a public good, not as necessarily as a source of profit for commercial interests. I was struck by the keynote speaker this morning saying that open source turned the notion of property on its head, whereas property had in the past been focused on the concept of who can I exclude from this. But with open source, as with open access, property and control comes down to who has the ability to distribute rather than who has the ability to exclude. So that would be the concept, especially if the material was generated by a public grant, as in the case of, or taxpayer money, as in the case of NIH, or taxpayer-supported research that's going on in public universities. Should we not have access to this type of information? In the context of using this buzzword open access movement, that's come to mean either one of two things, either open access journals or e-print repositories. In the case of scholarship, that would be pre-print or post-print archiving. In other words, it still presumes that you will publish this in a law review. You'll be branded, if you will, by having that law review citation. But leading up to that process, you put it in pre-print archives, making peer review possible. After publication, you archive it, retaining the right as the author to do that. Now, let's just for a moment review the traditional publishing model so we can compare it with the open access model. Under that model, we relinquish some control over that material in exchange for the convenience of having the publisher manage this for us. The information is disseminated by them. The print and the online journal serve as a repository. And in the case of peer-reviewed journals, there's that certification process. All of that's provided by the publisher. So it's a convenience. And then what happened was, at the same time online journals were becoming the preferred format for researchers, there was growing dissatisfaction with the traditional publishing model. Because because frankly, the universities were getting a short end of the deal. The publishers, sensing that they had a captive audience, were raising the price of these subscriptions at a tremendous rate, not in the law field so much, but certainly in the science, medical, and technology fields. And they were making a lot of profit off of virtually the free labor of the university researcher. And of course, the universities helped create this system by requiring researchers to publish in these top journals to get tenure. And as a result, you see profit margins of 30% a year coming out of the field of scholarly communication. You see the price of subscriptions skyrocketing when you're talking about these commercial journals, far in excess of the consumer price index. Here's a description of the subscription cost. Here we see the subscription cost exceeding the consumer price index. Here's just a depiction of the percentage increase over a 4-year period of time in some of the various disciplines. And we see the detrimental effect of this in other disciplines that rely on monographs. The humanities, for example, those scholars tend to publish their items in monographs, not in journals. As libraries struggled to try to find money to maintain these subscriptions that the science folks needed, they were cutting monographs that the humanities folks needed. The scholarly societies are also contributing to the problem. Their prices are also exceeding the CPI by quite a significant factor. So the libraries and the researchers, especially in the STM field, started to work together. Previously, for at least 5 years prior to this, the libraries were complaining about these prices, but it was sort of regarded as a library problem. It's not bothering me. I know it's a big, they're suffering into the money, but it's not affecting me. Well, as they're cutting titles, it does affect you as a researcher. You can't have access to the work of your peers. You just can't afford to buy the subscriptions anymore, and you need to know what your peers are doing. So the American Research Library folks formed SPARC. They actually formed that back in '97. It predates 2001. And they were one of the leaders in this area. My slide jumped here. Well, also Europe has been in the vanguard on this movement, possibly because they traditionally they didn't have the budgets to support some of those expensive subscriptions to begin with. So Europe got into the open access movement a lot sooner than the United States researchers did. There is, in fact, a number of resources on the web on these various movements, if you will. And there is support for the copyright issues provided by Creative Commons. Right now, there are public interest groups involved, specifically that's referring to the NIH recently announced policy supporting open access. There is Peter Suber, in particular, has done a wonderful job tracking what's going on in the various universities in this area. He has a list, a newsletter, and a blog that he maintains. You see here, probably not very well from your vantage point, but we've got University of California, Harvard, Cornell, the Triangle Research Libraries, MIT, of course, UConn, Stanford, Maryland, Indiana, Macalester, Carleton, Indiana, North Carolina, and University of Kansas. University of Kansas, in fact, the provost has issued a policy saying that university-wide, we will support post-print archiving of all of our researchers' work. Now, what happens is folks will often say, what about peer review? We need the support of those publishers in order to accomplish this. There's a lot of movement in this side of things right now. A lot of creative models are coming forward. Pretty much it involves cost shifting. Rather than having the publisher bear the cost of peer review, some of these experimental online journals are having the university or even the author bear the cost of peer review. That's something that's being tried right now with the Public Library of Science, where the author will pay $1,500 to have their piece peer-reviewed and submitted to this journal. So people are getting quite creative, all attempting to circumvent the publishers. Right now, SPARC is maintaining a directory of open access journals, and by most estimates, folks think at least 10% of all journals worldwide are open access. There are a number of law open access journals. In fact, if you have any that are not in this list, there's a submission form to nominate your own homegrown journals to add to this collection. Duke has a number of them. Duke, Cornell, and Harvard have been years ahead of most folks on this, by 5 years at least. And we're seeing all the Duke journals and have been supporters of this from the beginning. And we see all kinds of experiments going on with what folks are calling open access journals. Some are in fact completely free, some are only free abstracts, some are free after an embargo period, whether it be 6 months or 12 months, that type of thing. Now the interesting thing is, what's the impact of a freely available journal on research? And as you might expect, if your work is in an open access repository, it is much more likely to be cited. I found 2 citation studies reported. This earlier one came out of the computer science area, and this more recent one looked at 4 different disciplines. But they've demonstrated that you want your work used by other researchers, you do not want to put it in a fee-based subscription. You are hindering access to it, and your work will not be as widely disseminated. And there's an urban legend, if you will, or a truism. I've heard that the typical law review article gets looked at by 4 people or something. I tried to run that site down, but I didn't find it yet. But certainly the open access medium will mean your work is actually viewed by many people, and no doubt viewed by people in other countries as well. Folks that wouldn't normally see it when it's based in, it's locked up in subscription based. So as I mentioned, with a couple notable exceptions of our early adopters, law has been a little late to the table in this regard. It's just been perceived as not an issue for us. But the point I hope to drive home today is that, in fact, it is an issue for us, because this movement is based, again, on retaining the ability to disseminate your work and trying to wrest it back from this model that has the work bound up in profit-making enterprises, of which you have nothing, with which you have nothing to do. Now, there are a number of reasons why law has been late to the table. No doubt the main one is that our publishing system, especially with the journals, has been very decentralized to begin with. We have hundreds of law reviews available, and they are all decentralized. They are subsidized by the law schools. They are not controlled by the commercial interests. And you can see the price differential. the average of $200 for a commercial law journal versus $34 for a non-commercial law school subsidized journal. In just the last few months, there's been some movement in this regard. Dan Hunter published an article which is in SSRN, again openly available to the world, and the AALL formed a task force to look at this issue to see what it meant for legal scholarship. And Dan Hunter's maintaining a blog on this if you'd like to sign up for it and follow it. So at this juncture, now you have some of the background and know where this movement came from, I'd like to now focus on some of the various products that are available to you in the event that you want to form or create some kind of an institutional repository. Actually, how many of you are already at an institution where you have an institutional repository? So, yeah, his project at Cornell, more than 5 years ago, I think it was, created the legal education document system for faculty to load text documents into an institutional repository. The current state of the landscape has a number of heterogeneous platforms out there. So the big issue right now is, can these repositories communicate when they're based on heterogeneous platforms? How are we going to do that? And that's where all of the hot development work is right now in terms of developing or implementing harvesting protocols in a repository. To have interoperability, you obviously have to have some common architecture, and you have to have standards available and then implement those protocols. You will obviously have to implement the various harvesting protocols that exist and have available XML. Dublin Core is typically the metadata system employed, and of course we have to have open URLs. And this work primarily, I believe, has come out of what's called the Open Archives Initiative, the OAI folks. And one of their protocols, the protocol for metadata harvesting, is the system that DSpace has enabled. And what the harvester does is harvest the metadata, and if permission is available, you'll also be able to harvest the bit stream. Now, as non-law disciplines especially load more and more complex data sets into this, more and more robust protocols are needed to be able to harvest those objects, because that's the goal. You don't want to just be able to read about the thing. You want your harvester to actually gather these objects. You're going to use them in your work and create another value chain, if you will, especially in the non-law context. So it's a very hot area right now. Interestingly enough, one of the older harvesters was Oyster. You probably heard of Oyster. I just noticed some of their sites here. They're continuing to harvest new servers that they're finding. And if you have time, you might want to play with Oyster's search screen. It was pretty good. You know, it did a good job of pulling up the items that are out there. They're harvesting from more than 400 repositories right now. So, before you pay money to license a proprietary institutional resource, I would encourage you to look for an open source repository at a university near you. That's what happened at UNM. Luckily, the university was ahead of the curve on this, and they put up a DSpace server. Now, obviously, if you're in a private school, you don't have the ability to work with the university, but you might be able to work at a consortium level. For example, the New England Law Library Consortium, the NELCO folks, have implemented a repository using ePrints, which is another open source repository program. The other option you have is to spend money on something like Berkeley Press or SSRM. And we'll talk a little more about those in a few moments. At this juncture, we'll just spend a little time looking into some of the at a deeper level, looking at DSpace and the community of developers that has arisen. There's a lot of documentation on the web if you're interested in that, and a number of reports. I'm not going to pull these all up at this juncture. But there are at least 75 DSpace servers out there currently. Here's the list that we have at the moment. Brigham Young, they have a law school, but there's no law presence on it. Case Western, again, no law presence. Arizona, no law presence. So these resources are just sitting there ready to go if you're interested in it. Some of the folks have very elaborate servers. Hong Kong, I'll just show you, they have a very robust and well-developed DSpace. There are thousands of submissions in here. That's one of the better developed ones. University of Toronto also has a very well-developed DSpace. So it's limited only by your imagination, since this thing will support any file format. The developers meet annually, sometimes twice a year. The next meeting will be in a month in Cambridge. Good excuse to go to the UK, perhaps. This is just a quick peek at the architecture, if you're interested in that. I'm definitely a user, not a developer. So I hope you don't ask me too many technical questions on that. But from my reading, I did learn that each one of these modules can be independently enhanced or replaced. So if you want to change the web user interface, as a number of Toronto, for example, they call it DSpace rather than DSpace. So you can customize the interface, you can customize all of these modules. Now, the other most commonly used open source package is ePrints. Duke is using that for their legal repository. Is anybody here from Duke? The ePrints folks maintain an archive of IRs currently in existence, both DSpace and ePrints. The ePrints are in green, and the DSpace and others are white. So as you scroll through this list, you see how many folks are using ePrints. And there are 434 in total. And a number of these are from other countries. It is truly a global phenomenon, and it's one that's been kind of going on without law paying much attention to it at all. Probably because we've already sort of bought into this concept of SSRN becoming our primary repository. Most people have SSRN site licenses, and our faculty are probably getting emails announcing submissions. Berkeley Press is the new kid on the block. They became available in 2004, and they are working on trying to get some of the market share that SSRN currently has. They have similar services. Legal Scholarship Network, as you probably know, support open access journals. Any author can submit freely those subject-based journals that LSN maintains. But then if you wanted to host an institutional repository, say you wanted to have the University of New Mexico research papers collection, you would have to give them a fee between $6,000 and $10,000. They will host the server for you, and you can regard it as your repository. Now, it's limited to journals. You don't have the flexibility you would with DSpace or eTrans in that you can load virtually anything into it. But if your faculty don't know how to PDF something, you don't have an infrastructure to help them with that, and you don't have the ability or the programmers to work with the open source code, you might have no choice but to fork over some money and outsource this if you will. So that's definitely an option. Although I do have some concerns about that, which we'll discuss in a minute. vPress is a similar concept. They host your repository for you. Typically, the author loads the text document into it. It's PDF. It's secured right there in the submission process. The metadata is added. LSN, I'm not positive about their metadata. vPress uses the current index to legal periodicals as the basis of its indexing metadata. This is very appropriate for legal scholarship. And the vPress software is currently supporting the University of California repositories. NELCO chose to use vPress, and vPress also has a project now with ProQuest to make this software available for people loading dissertations and theses. So we've got a lot of play in this area right now. Number of products, both open source and proprietary. And when you read the documentation on the web about this, the folks are trying to introduce IRs at their institutions, you'll see a recurring theme, and that is it's very difficult to get the faculty to pay attention. If we build it, will they come for that? But we need to be patient in this regard. It takes a long time to change the culture. It's maybe less so in the law even than some of the scientific disciplines. They are very locked into having published in certain journals for tenure. And trying to shift a culture that would allow you to retain control of your work rather than lock it up in the commercial enterprise is a radical shift, and that will not happen overnight. So this particular area seems to be at the phase now where the really heavy lifting of meeting, marketing, and awareness campaigns is coming into play because the programming is pretty much there. Now, what's interesting when you look at the implications for legal scholarship, in my opinion, is that unlike other disciplines where peer review was possible because of the commercial publishers, I think institutional repositories for the first time make peer review very feasible for law. Something that was not so feasible when you were looking at hundreds of decentralized print law school supported journals. So in the web-based arena, you truly can collaborate, and that's what we're seeing with folks loading things in SSRN and getting comments from other authors and numerous revisions being placed into the repository. I also think open access as a concept is very consistent with the culture of the legal community. We have, as a country, always tried to make legal information available to citizens. So this is not inconsistent with that culture in any way. The other thing that is discussed, and nobody has a crystal ball to see what will happen, but what will happen to print law reviews? As legal scholars begin to embrace the concept of open access. Now, I maintain that they can continue, you do want your article to be accepted by a law review, at least for the next foreseeable decade or so. I'm sure authors want to be branded, if you will, and have their work accepted by the top law review if possible. That will not go away in the short term. Now, we might also think that this will just kind of go away because the commercial interests will wise up and they'll stop charging exorbitant sums. In fact, we are hearing that a number of universities, now that they have the leverage of the institutional depositories behind them, have been able to negotiate with these publishers and get the prices down. Well, what's interesting is, while we're seeing that occurring in other fields, in the law, we're seeing price increases. So we seem to be out of sync with what the other disciplines are doing. In fact, we are starting to move in this online arena. We are moving towards centralization. We are beginning to centralize in things like SSRM and in B-Press at a time when other disciplines are trying to decentralize. So once again, the law seems to be out of sync with what our colleagues across the street or across the river would like to do, which is a little troublesome because I would hate to see legal scholarship evolve to an online area where it's all bound up now with commercial interests to the exclusion of some of these open source alternatives, especially where there may be one waiting for you at a university ready to go. So, any questions? Yes.
To what extent do you think that legal literature has been available in full text since the mid-70s into this?
Well, the question was, what's the impact of having full-text legal scholarship being available online since like the mid-70s, early 80s? But it hasn't been fully available. It's been available in subscription-based containers, if you will. Westlaw, Lexis, now Hine Online with the back file.
We're talking about academics, though. Main law schools that don't have Lexis or Westlaw.
We're not talking about making it available to law. We're talking about making this available to the world. If you as a researcher would like to have your work used by a comparative law scholar in France or in England, the odds are they do not have access to your work. It's bound up in the commercial interest. Tom, did you have a question or comment?
If you want me to name a law school that doesn't have significant access to American legal scholarship or Westlaw practice, that would be a law school outside.
An interesting project would be to do a citation analysis and see if we can detect the impact of open access on legal scholarship already. It's in its nascent stage, and I'm not sure that it's there yet. For example, does Shepard's track open access journals? Do they track print? But a citation study would probably need to pull in European scholars because of the ubiquitous nature of Westlaw and Lexis. There'd be no way to control for that in the United States. You'd have to do a much broader citation study. Yes?
Yes, I just have a question about the metadata. How are you actually attaching the metadata? Is it the author or somebody else, or is it a mechanized process? And is it really necessary if you're putting the full text of the materials into pieces?
The question is, who attaches the metadata, the author or someone else? And is it mechanized, the attachment process? And is it necessary if full text is going up? Currently in DSpace, I'm not familiar with ePrints at this point, but with DSpace, the submitter attaches it. And the submitter might be the author, or it might be someone in the library who's been tasked with helping authors. that's what the model we're developing at UNM would be to have a staff person assist faculty with the submission. Because there are some studies, Steve Harnett did a time study that showed that it takes about 10 minutes for the average submission because of the metadata attachment. And you do want to have the metadata because that's what Google is searching, especially if it's an image. Yes?
Yeah, how do you deal with faculty opposition or reflections by faculty to participate in the course?
Education, how do you deal with faculty who may not want to change or just ignoring this? And in my case, in my experience, when faculty saw the extent to which this gave them the ability to retain control over their work and make it more widely disseminated, they were very supportive. The archive aspects of this system were a slam dunk. I mean, I have people coming at me with, file cabinets full of stuff saying, "Oh, please put this into DSpace. I've had it in my office for 2 decades, and I haven't had anything to do with it, and no outlet for this." Again, libraries in this era, I think, need to think globally but act locally. We have a lot of unique gems at the local level that if we could have a way to share would be very valuable, or at least to our immediate community, our region, our state. So I've been surprised at how willing they are to embrace this. With regard to publishing their scholarship on this, and the need for post-prints, if you will, when it's been published in a large already. We recently had an incident, I took it out of my slides because it didn't really seem to fit with the flow of things, but Thompson Gale entered into an agreement with Amazon a couple of years ago, actually, and the full text content in Legal Track, and there is some in there, they're selling those articles on Amazon.com for $5.95 an article. One of our faculty discovered that one of her articles was for sale in Amazon for $5.95. And she came to me and said, "How can that be?" But Thompson Gale has a disclaimer on there saying, we have a right to do this with these articles. If any author discovers and feels that we don't have the right, please contact us and we'll take it down. But that really brought home the fact that they have lost control over what's done with their work. Coming back again as a keynote speaker, the ability to control the dissemination of your work is what's at issue here. It's not library subscription prices. It's not that we're all communists and don't want the publishers to make money. What's at stake here is control over your work. And if you're the typical researcher, you want your work to be read and seen by as many people as possible. So it runs counter to that to have your work bound up in these 4-fee repositories where most of the world cannot access them. So they get they get that just immediately. So the Amazon thing really helped. Yes?
At UNM, have you all looked into using DSpace or something similar as a way to get tribal court decisions online and make those more widely available?
The question was, are we looking at tribal court decisions and as a possible item for DSpace? And we definitely are. We currently have access to tribal court decisions only through the Tribal Court Clearinghouse and through Versus Law. And in New Mexico, we have about 30 separate tribal entities. And most of those decisions are not available. It would be a wonderful use of DSpace. Realistically, though, as we all know when we work with Indian law material, getting the material released for a project like this would be difficult. It all comes down to relationships. have you built a relationship with someone inside the tribe to the extent that they would trust you enough to release it or commit to making it available routinely? Although I would take what I could get, whether we continue to get it would be another story. We have actually made a lot of progress in the last year with, in that regard, a number of our graduates from the law school are now working back within tribal government, and we're working on developing some of those relationships. And we received seed money from the legislature this year to actually go out onto the reservations and do online training in the context of one of our clinical law programs, the pro bono program where the folks take the Indian law cases for free or for reduced fee. So that's giving us an entree into the reservation we've never had before. And hopefully we can build that relationship and try to get some of the primary material in exchange down the road. And I definitely would be stashing it into DSpace. We could do a web gateway very easily. It would be indexed by Google, and it could be available to everyone. So it would be a perfect fit. Yes?
Is the DSpace community pursuing any rights management model or metadata? We're talking about distribution rights rather than specific rights.
I couldn't hear the last part.
Like a Creative Commons license.
I don't believe that they are.
Actually, yes.
They are? Oh, good.
There was just a draft standard put out by the OAI looking for rights metadata associated with OAI documents. You can find it on the OAI website. They one had books in it that would allow you to incorporate references to Creative Commons licenses, if that's what you want. Anything that imposes actual access control restrictions on the document itself, you can't really do in that model because it's all about metadata, it's all about the document itself. Although there are obviously secret schemes for all sorts of stuff around anything that
In that, yes?
Is there anything in DSpace or in other models doing quality control of the metadata? I was just looking at DSpace actually, and here's the same author. This where you browse authors. It's the same person listed twice, once with a period after the middle initial and once without a period after the middle initial.
It depends on how the system is set up. You have the ability to allow people, as I mentioned, to serve as a gatekeeper. And hopefully the gatekeeper does impose some quality control. But if the system was set up and they allow the authors total control of the metadata, you will encounter problems with the indexing almost certainly. Tom, do you have something to add?
Big aggregators, like National Science Digital Library, whose metadata specialist, by the way, is World Law Catalog, it's one of the people does it with a variety of sort of post-processing techniques because they are actually aggregators that don't have any control over the metadata sources. They've done all sorts of interesting stuff programmatically, including the use of kind of large-scale visualization software as part of repetitive viewing. It's a very hot topic in research right now, and very much on everybody's mind. It is not wrong.
Yeah.
Out of the box, does DSpace give you some way to control whether or not you're indexed by Google, now that you have the Google Scholar stuff working?
Well, you would have to disable the OAI protocol, or I don't know.
I say
if
that's
you
a
can.
no. It doesn't get in the way, right?
It'd be pretty easy to hack it on because really all you have to do is suppress the OAI transmission of those records, which could be as simple as marking the field in the database with software.
A continual issue at Emory is that we're very well indexed by Google, and we have a lot of court of appeals decisions that people are unhappy to discover are at the top of any search on their name. It's a recurring issue for us, actually.
Let's do it.
Are they images or text?
No, these are the text
They're
of
text.
the decisions of several courts of appeals.
If you just fail to fill out the metadata fields, Google wouldn't have much to go by with the image.
Google full text indexes everything.
Well, our time is up. Thank you very much for your time.